Welcome back to Supreme Myths. I'm excited today to have as my guest Professor Michael Smith of St. Mary's Law School. Michael is a graduate of UCLA Law School and the University of Iowa, where he received a BS and a BA in political science and in philosophy. He has been a lawyer. He has been a law professor. He is a young law professor, a relatively new law professor, and his work became a huge part of my focus because I don't know if anybody right now is writing law review articles better about originalism than Michael is. And obviously that's why I wanted to have him on the pod. Michael, thank you so much for being here.
Thank you so much, and thank you for those kind words.
Now, let me say at the outset that I have to do some apologizing here. First, we are taping this on what is today? On Wednesday. And the Supreme Court just issued two opinions and kind of accidentally released a third that will be known by the time this podcast is released. We have opinions coming down Thursday and Friday and maybe Monday. We are not going to, this pod is going to come out after all of that because I want Michael's views on this not to be lost in the shuffle of the huge term cases that are coming down. So this pod will be 4 or 5 days old by the time you hear it, but that doesn't mean it's untimely. It is in fact incredibly timely. And one last disclaimer before we begin. Everybody who listens to this podcast knows that I am an originalist critic. So is Michael. Now, I have had on this podcast Randy Barnett, Michael McConnell, and a bunch of other high-profile originalists to let them tell their side of the story. Today, you're going to hear one side of the story. Now, we will do our best to keep it honest and true, but you are dealing here today with two people who agree on 98% of what we're going to talk about, but not 100%, and we'll try to find that space as well. All right. Michael, you've written articles. I am so jealous of your titles. Moral Panic in the First Amendment. Library Crime. We're not going to get to that, but it sounds great. Constitutional Interpretation and Zombie Provisions in Georgia State Law Review coming out. We'll get to that too, maybe. I'm not sure. And a bunch of other great titles, but your best title to date, I tell my students, say exactly what you mean in as few words as possible. And your title of your most recent piece that I'm interested in, you have too many to count, is, and I'm going to say the title only one time, and then I'm going to explain why. The title of Michael's article we're going to talk about today, which does bring on his previous work as well, is Originalism Bullshit? Now, this is a family show. I have daughters, 3 of them, although one is adult. We're not going to use that word. We're going to use the word BS. Is originalism BS? So that's the topic, and that is the topic of this podcast. Is originalism BS? Michael, why did you write this piece? How is this situated in your previous work, and what motivated you, and especially what motivated you to title it the way it did, because it's obviously a very controversial title.
Well, of course, so I got interested in originalism and constitutional interpretation a few years ago, around about 2020 or so, still in practice. I was cooped up during the pandemic and decided to start writing about constitutional interpretation. I love to write, and it's great to write about something that I wasn't dealing with in my day job because I wouldn't get in trouble at the firm. And originalism, constitutional interpretation, that all was something I was fascinated by and particularly critical about. And the idea of this piece came into my thinking because my broader concerns are over sort of candor and transparency in the interpretation process. That's motivated a lot of my earlier work, a lot of my ongoing work. And this was kind of an offshoot from that. I figured that I was familiar with the literature on BS well before I became a lawyer. And I thought, well, it'd be a fun distraction essay between serious projects to write a little paper on it. And as many of those projects do, it evolved, it grew, and now it is a full-on article that'll be coming out, I think, before too terribly long in the Lewis and Clark Law Review.
So I want to be clear about one thing. So the title is Originalism BS, might lead readers to think this is not on the academic side of your writing, or less academic than some of your writing. That is unequivocally not true. The first, third of the article, maybe more, gives a very academic, scholarly type approach to what is and what is not BS. So let's start there. And I do we will return to your views on transparency and candor, because that's been a big part of my career. And a lot of what I've talked about for 34 years about the Supreme Court is their unbelievable lack of candor among many, many, many dimensions. We'll get back to that, I promise. You know that's near and dear to my heart. But first, give us a definition of BS that we can use shorthand. You can't do total justice to your academic work here because it's actually pretty thick. People will be surprised. But which is a compliment. But give us your kind of podcast, summary of what is BS and what isn't BS.
My elevator pitch for BS.
Yes, thank you. Thank you. Yes. By the way, I'm very jealous of your voice. You have like the best radio voice. If I had your radio voice, I would be on XM radio right now with my own show, and I wouldn't be this freaking law professor thing. Okay, go ahead.
My classmates used to call me NPR. That was one of my college nicknames.
Yes, yes, NPR.
And I'll also say the background section used to be quite a bit longer. I was told to cut it back, and I have.
Yeah.
But a working definition, this does harken back to Harry Frankfurt. He is sort of the core, I think, scholar who's really dug into this, who sort of introduced the word to the literature. And it's essentially the idea of communicating something to someone else without regard for the truth of what you're communicating, all in the furtherance of some other goal beyond communicating the truth. And it doesn't matter whether what you're communicating ends up being true or false. You can BS someone and end up telling them something completely false, or you can BS someone and end up being true. The core is that you don't care. You don't really have much regard for the truth of what you're saying. There's something else going on. It's also distinct from lying, where you know what you're saying is false and you're telling a lie to mislead the audience. So I try to walk that line.
So wait. Stop right there. Hold on. And that got me thinking in your article. Your whole article got me thinking much more than I thought it was going to. Because God knows I've waded in these waters. Not the BS waters, but the other waters. But wait a minute. So I want to convince someone to do X, and I'm going to lie about Y that I have every reason to believe will convince them to do X. But if I wasn't lying about Y, I have every reason to think they would not do X. That's not BSing? That sounds like BSing to me.
If you believe that what you're saying is false, it is, I think, generally going to be a lie rather than BS. BS, it's not so much a knowledge of the truth or falsity of what you're saying, but the disregard that's important. A nice example that I was just thinking about before the show is, let's say I'm giving a talk at, a job talk or a workshop, and someone shoots a comment at me that I'm not ready for, and I'll give my standard response. That's a fascinating comment. I haven't really thought it through all the way, but I'll look into it and incorporate that into the next draft of the paper. I'm in the heat of the moment, not at all sure if that's something I'm actually going to do. Is that going to make the paper disjointed? Is it something I intend to do? Maybe I will, maybe I won't. I'm trying to keep the conversation going, maybe please the audience or something like that if it's a job talk and I'm trying to get hired. That's really my goal there, rather than genuinely communicating the truth that I intend to do that work and change the piece potentially based on that comment.
So that example confuses me a little, and let me mention why. And let me also say, again, if you the audience, anyone listening to this, if you don't care about originalism or the Supreme Court at all, that's totally fine. If you're interested in BS, what it means, what it does, how it works, this is a great article. So there's two different reasons to read this article. Really, honestly. So I'm confused. And so the questions I'm going to ask are based on my excitement about reading this new idea that I haven't really thought about in an academic way before. So I'm confused by that, Michael, in this sense. When you're in that moment, you're acting in good faith. Like you may follow up, you may not, but now isn't the time. And you're going to put them off. You're going to do what's necessary to not insult the questioner. And then it may turn out to be true, what you're saying. It may turn out not to be true. You don't know. If that's the kind of BS we're talking about, it feels very, very mild to me. I think what I would have thought was be more BS would have been, I'm never going to talk about that, but I'm going to get through this the best way I can, so I'm just going to, fib for a minute and move on. That to me feels like, but that's a different thing, though, I think.
I call that a lie. If I know, as soon as I hear this question, that this is something that is completely out of left field and has nothing to do with my paper, I make that statement. I know I'm not going to follow up on it. I'm just trying to please them and make a good impression, maybe get hired. I would say that'd be, a lie. I know what I'm saying is false, and I'm trying to mislead that questioner. Sorry, go ahead.
But can't BS be in the toolkit of liars?
I think it's. I think we're maybe you can be someone with a hazy relationship to the truth or an inconsistent relationship to the truth.
Okay.
In some instances you might lie. In some instances you may BS, and it depends on, I think, the circumstances, and I think in terms of severity, it also might depend on the context. If I'm BSing in some workshop to which I was invited and the stakes are relatively low, I might end up BSing, and we all may kind of expect that, and it's going to be fine. If I'm BSing and I'm a justice of the Supreme Court writing an opinion about the rights of millions, then the same type of BS may be quite a bit more concerning.
So I'm drilling down on this for a reason, because the one substantive comment I have about your paper, which I found otherwise perfect, is going to implicate this. So that's why I'm drilling down on this. When I first saw I think on Twitter you first just posted it, right? The title. I'm thinking of this new article, and you posted the title. And I loved it. And when I first saw it, though, I guess what hit me was, for something to be BS, there needs to be an element of something bad. In other words, if something is just a positive good, that can't fall in the BS category for me. But I'm not sure if you agree on that. So I want to get that on the table before we start talking about the Supreme Court.
Absolutely. And I think that's kind of where we run into maybe a difference between colloquial BS and this sort of more academic concept of BS. I do think it is bad in the Supreme Court and constitutional context. I think that BS in other contexts, though, could be perfectly benign, even expected, even maybe a fundamental part of how systems run. I say that, as a former litigator, for instance. We have BS artists who are renowned for their skills in certain areas and contexts. So I think maybe where the tension's coming up is this sort of concept and academic notion of BS, where I think the negative nature of it comes up. It could be in terms of those who really value truth. I sort of end the paper, for instance, with a discussion of St. Augustine and his commitment to the truth, sort of come what may. People who are very concerned with the truth, Frankfurt as well, is very concerned that this disregard for truth is a big threat to honest discourse and communication. So even if we see it as mild, maybe that's a bad part of it. I don't focus so much on that. I'll leave that for the philosophers to debate. For me, it's in context of the Supreme Court. I do think that BS here, while in other instances maybe benign, does have some pretty profound implications.
One final introductory question about BS then. So this is why I'm having some difficulty getting to your bottom line, I guess, on what BS is. So this is my podcast. I get to mention Richard Posner once a podcast. I think you're number 123, I think. And in about 121 of those, I've mentioned Richard Posner. So I'm going to do that right now. So when I was trying to figure out Justice Scalia, what made him tick, who he was, I went to Posner, who I'm good friends with, everybody knows that, before he got sick. Dick is now very, very sick and can't communicate. And we had a long, long talk about Scalia. Humorously, at brunch at the Four Seasons Hotel in Chicago, where his wife eventually had to shush him because he was talking about Scalia so loudly that everybody was paying attention to Posner ranting about Scalia in a busy lunchroom. But this is what he said about Scalia, and the reason I'm asking you this is I want you to answer for me, is this BS or not? And then we'll move on to originalism generally.
Sure.
This is how he describes Scalia. Obviously a person of high IQ. Brain power, just the engine in Scalia's brain. No one is going to not deny that was a serious engine. Very highly smart person. But very narrowly focused. Too narrowly focused. It was his lens wasn't wide enough, according to Posner, to be a true intellectual or to be someone who's really curious about things for a number of personal reasons. But that's not what I want to ask you about. Then Posner said, and this is so interesting to me, Scalia was told as a law student, this is what judges do. Scalia was told as a lawyer, this is what judges do. As a government official, when he was working for the executive branch, this is what judges do. He becomes a judge. And what judges do is not make stuff up. What judges do is follow the law. They don't, et cetera, et cetera, et cetera. And Posner really thought that Scalia's blind spots had a lot to do with the following phrase: cognitive dissonance. Like he just couldn't, he was brought up in a way that did not, and because he was relatively closed-minded to begin with, he could not widen his lens to really, really get down and dirty with differing views. So he used BS a lot. That's Posner's view, but not intentionally. Not intentionally. It's because of the environment in which he grew up in. So let's take just Scalia, dissent, Morrison versus Olson. Everybody says the best dissent ever, his best opinion ever, blah, blah, blah. But he completely misquotes the First Amendment in the very first sentence of the first paragraph of the opinion. I'm sorry, not the First Amendment, the Article 3. He completely misquotes it. Article 2, I'm sorry. Here's my question. If someone is engaging in BS for their entire career, but is doing so because of cognitive dissonance, is that BS?
It's a tough question, and I think it may relate to, I think, something we're going to discuss in a bit. But if the cognitive dissonance, if one's background is truly in such a way that what they believe they are doing is correct and accounts for everything that needs to be accounted for to go into that final decision, that view of the evidence, the history, the text, they genuinely believe that they have the universe of facts at their disposal and are employing it appropriately. I think in those cases, that genuine application would not be BS. I would sort of classify it as an earnest mistake if they're in fact doing something wrong, but believing truly that they're doing it the right way. Now, can we say that that's what Scalia was doing? I would have my doubts because, like you said at the top, he's a smart guy. He is a quick thinker, is exposed to constant ideas, exposed to frequent criticism as well. And unless something's going on that simply somehow shuts that out, some unintentional shutout of the criticism, I think then we're at a point where doubt might start to creep in, and awareness of possible alternatives or evidence beyond one's preconceived notions begins to creep in. And that's where BS, I think, becomes more likely. An analogy I kind of like to give is to First Amendment law and reckless disregard for the truth in New York Times versus Sullivan. It's this idea that, you have some doubts over what you're saying, it might be false, but you just go ahead and say it anyway. That, I think, maybe not a perfect analogy, but a helpful one, especially to those more familiar with constitutional law and sort of understanding kind of what BS is and the role it plays. I'm going to really try not to say the actual word, but it's hard.
It's okay. I think that's a great answer, Michael. That's a really smart answer. We could spend the next 17 days talking about just that topic, but we're going to move on. We could, but we're going to move on. Okay. Can we define originalism with some degree of generality so that we can ask the question, is originalism BS? And try to, even Professor Larry Solomon, among others, was, one of the leading new originalists of our day. Even he would say it's a family of theories. So obviously originalists disagree with each other about a lot of different things. So can we figure out a way to define it at a level of generality that most originalists would say, yeah, that's the core of my thesis. We're going to disagree how it applies in the real world, but it's the core of our thesis. Can we do that?
I think we can, at least for working purposes. That's what I try to do in the article as well.
Yeah.
Professor Solom's conception of originalism I have found consistently helpful in writing about originalism. I think he does a fantastic job of really fleshing things out and sort of explaining the scope of the debate and the options. I think this idea of kind of meaning being fixed at the time of ratification, coupled with the idea that we should follow that meaning, is a good way, a starting point. I do think that the BS and the tactics that I discuss in the article, though, might even be a little broader. And it generally kind of relates to the use of history and the investigation needed to determine that fixed original meaning. And I think as a result, some of my BS discussion applies maybe not only to that originalist endeavor, trying to figure out the original meaning or the original law, if we're taking maybe a different approach to originalism, the original intention, all of which involves this kind of historical analysis of some sort. It may also apply to, I think, traditionalism, which Mark de Girolami, I think, has really been expanding and expounding upon, which I think is a great way of thinking about some of these cases, an accurate way, at least, of thinking about some of these cases. And so to bring it all back, I think that family of theories approach, particularly the idea of some fixed original meaning, that is, I think, mainly what I'm focused on in going forward, because that notion in itself carries certain assumptions. There is a fixed meaning, there is a singular fixed meaning potentially. That is what I think is the focal point of my piece, as well as my concern over institutional demands that I think complicate that inquiry into fixed original meaning.
So I think that's a great answer, Michael. Thank you. I think we can say two things then, but correct me if I'm misinterpreting what you're saying. I think we can say virtually all originalists today accept Solom's fixation thesis, which is, as you said, the original meaning, the original communicative content, the original meaning of the words is fixed. And when knowable, binding on judges, Solom concedes that it's not always knowable. How much he concedes that, he's never said. So we don't know how much he concedes that. But he does concede that a little bit. And then I went at it. So we have those two things. And I think all originalists would say, obviously, the study of history defined very broadly, whether we're talking dictionaries or treatises or public opinion polls from 1917, whatever it is, there is a premium, at least, on historical investigation. Is that fair?
I think that's fair. And I'll also say, often when I am sort of talking about originalism, I usually do kind of default to this sort of dominant form that I think you're describing as well, this original public meaning notion of originalism, where we're looking to some public meaning of the terms at some relevant fixed point in history, usually ratification, although, you add the 14th Amendment into it, many possible problems that I certainly don't get into in this article.
Okay, so let's start with this, okay? Hundreds of law professors in America and hundreds of judges in America believe that the Constitution, that the original meaning of certain constitutional provisions is fixed. If they didn't believe that, they wouldn't adopt this theory, because it'd be a silly theory if you didn't believe that. I want to talk about that idea. So let's concede that the word 35 has a fixed meaning. Can we concede that?
Reluctantly. Yes, of course.
Yes. Okay. And we could concede 2 senators from every state has a fixed meaning.
Yep.
And let's also concede for the moment, neither you nor I have the answer to it. I don't think either of us know this, but technical terms of art that we don't use anymore, that are in the Constitution, likely have a fixed timed meaning. But we don't litigate any of that. What we litigate are words like free exercise, establishment of religion, abridging freedom of speech, unreasonable searches and seizures, cruel and unusual punishments, equal protection, due process, double jeopardy, etc., etc., etc. Is it BS for any thinking human being to say those terms have a fixed meaning?
I think it depends on how they say it. For instance, if we investigate history and we canvass instances of usage. Maybe we do corpus linguistics or something like that, assuming we do it correctly. A bunch of different terms, a bunch of different writings. Oh, I have my issues with that as well, but not the time or place.
Yes.
If you present it as saying, based on what we have uncovered, we have determined this to be the original meaning. And perhaps if you acknowledge competing evidence or something like that, I think there's a possibility that it's not necessarily BS. I qualify this, and I'm hesitant, because so much evidence is necessarily going to be lost along the way or not sufficiently preserved. I mean, what are the writings that we're analyzing if we're canvassing over a bunch of documents at the time of the founding? It's probably going to be a bunch of letters, writings, and things by elite white men. Some people have done great work into trying to expand the corpus, argue for the consideration of alternate sources. Christina Mulligan, I think in particular, comes to mind.
At Brooklyn, right? Brooklyn.
I believe Brooklyn, But if that doesn't happen, and if we're making proclamations about fixed original meaning, and we're maybe not taking that into account, perhaps with an awareness that it might be out there, now we are potentially, I think, crossing the territory into BS. And perhaps and I do think we are in a BS territory even more strongly, perhaps even into lying territory, if we're making claims about obviousness. This is obviously the original meaning of the right to keep and bear arms. And anyone who disagrees with me, is, smoking something. I think you had Eric Berger on your podcast a while back talking about this absolutist concept. And I think those instances in particular are, at least BS, if not, maybe outright dishonesty to the extent that people are on notice of the counter argument and proceed not just with the conclusion, but assert the obviousness and unquestionability of that conclusion.
First of all, thank you for listening. Eric Berger is a great guy, and that's a good friend, and has really written beautifully about the nod to certainty that the Supreme Court does all the time when things are far from certain, and we'd all agree things are far from certain. I want to drill down, Michael, on what you just said. So I won't give away the end first. Your article concludes, if I'm wrong, but no, you do it. Tell me I want to get back to what you just said. Before I do, what is your conclusion? Let's go to the bottom line. I want to work backwards.
Let's go to the first page of the article.
Yes. Is originalism BS?
Of course, no. So the answer, awfully law professorally, is
it depends.
It depends. I do start with, I won't give away the game, but as I've suggested, as I've hinted already, it very much depends on largely level of knowledge. I think also on institutional demands and pressures have a great influence on this. And I draw the line between instances of where I think we can have, let's say, false statements, maybe even true statements about history that are earnestly mistaken or limited because lawyers, judges are not historians, and they may well think that they have a handle on it when in fact they're completely out of left field. And I do think we can, though, cross the line when there is that awareness, there is that broader knowledge, there is that selective approach to history from the outset to win a case, to reach a single decision, to make tenure, that drives the inquiry rather than an actual search for the truth of the original meaning. And that's what I really drill down on. The institutional demands at all levels of originalist practice, inquiry, and research that potentially corrupt the overall endeavor and lend the theory towards BS more often than not, potentially.
Spectacular answer. So I'm going to tell you something, and I want you to tell me if a person believes this. Is it BS? Okay.
Okay.
So, the First Amendment: Congress shall make no law abridging the freedom of speech. Now, let's concede that there are some fixed meanings about that. For example, the NBA must get rid of its three-point rule and go back to its old system of just two-point shots because of the First Amendment. Would be stupid, dumb. Nobody would say that. And it's not part of the possible constructions of the First Amendment. I get criticized by Christopher Green and others for saying anything goes. And I'm not saying anything goes. What I'm saying is in any litigated case, it is likely the court can rule for either party in a non-frivolous, meaning Rule 11, non-frivolous manner. So I want to get the straw man out of the way, okay? I'm not saying the First Amendment can mean anything to anyone at any time. That's a nihilist. I'm not that. Nihilist, whatever. I am not that. I'm accused of being that. I've never been that. All right. End of speech. Now, someone who says the best way, we have a problem in America. Florida, and now by the time we had this conversation, the case is going to be out. But nevertheless, Florida and Texas want to regulate social media companies in a certain way. Doesn't matter. I don't even care. Forget the details. They want to regulate them. There are private companies. The general idea would be, no, they have a right to free speech. You can't tell them what to say, what not to say, because they're a private company, not the government. And someone says, well, the original meaning clearly points to X or Y. And I want to say, there's no one on the planet in 1791 or 1868 who anticipated the internet, and there's no one on the planet, even if they could have somehow anticipated the internet, thought about what that would mean for free speech law, that hadn't been born in 1868. The Supreme Court's First Amendment decisions were 1920. So, to me, it is BS to say the way judges in America should resolve that case. Can Florida and Texas regulate Facebook and Twitter in ways we would think they couldn't do because of the First Amendment? let's figure that out by looking at the original meaning of the First Amendment, is pure insanity and BS. If someone said that to you, am I engaging in BS right now?
I would say probably. It
Okay.
sounds like you're, and I'm hesitant because
No, go ahead. It's okay.
the divide I'm considering is BS or outright lying.
Okay.
If you know as much as you do about original history, the limited protections provided at the time of the founding, if you've done research into even the law review literature, great work by people like, Judd Campbell, Genevieve Lockyer, and the like, you'll know that some of these phrases, some of these absolute claims are probably...
No, Michael, back up.
doubtful.
I'm sorry.
Oh, sure.
I wasn't clear. No, my fault. I wasn't clear. I'm not suggesting how these cases should be resolved or what it means. What I'm saying is no sane person can think that to resolve the very difficult questions arising from our desire in a country to have freedom of speech and Twitter and Facebook being so big, so large, so unanticipated, have so much power, whatever our balance ends up being, we're not going to glean helpful materials to strike that balance from 1791 or 1868 because there's no analogy that's even close. And there was neither the law nor the facts in 1868 so why are we asking about 1868 or 1791 when I'm telling you it's no help? Now, can we make creative analogies at some far point? Maybe. But generally speaking, it's not the way to do it. We got to take into account today's values. Someone who says, no, Siegel, you're wrong. Original meaning is the way to go to decide whether or not Florida can regulate Facebook in this way. To me, that's BS. Is it BS? The question, not the answer. Yes. It is BS. Explain why.
I think so.
Okay.
The example that you're raising is, I think, so disconnected from, the founding, the circumstances at the founding, that to claim that I think the original meaning provides us with the answer is itself, that sort of level of exclusivity and certainty, I think, takes the statement into BS territory.
Okay, hold on. Oh, hold on. So Randy Barnett and Larry Solomon would respond to you and say, no, we're just saying at that point we go into the construction zone where originalism still has to be a thing and it has to be consistent with originalism, but we may have to extrapolate to today's facts and events. With that caveat, does it take it from BS to non-BS?
I think that the way it's presented, where we're still sort of doing an originalist inquiry, I think we're really walking that line. I don't think that history and original meaning is useless, perhaps not even in a case like this, but to state that that is the inquiry and to state that construction is anything other than really incorporating modern circumstances, cost-benefit analysis, and the like, which I think in many of these very disconnected cases it will be, is to, I think, hide the ball of where the actual work is being done. It's being done almost entirely in the construction zone in a case like that. It's being done by the doctrine. It's probably going to be resolved, through common law. There was a fantastic line in the Fifth Circuit's opinion, I think by the majority, chastising the parties for not engaging in history and tradition analysis and for relying on Supreme Court doctrine, which is just, that's how things are done in the First Amendment context. We cite the text, we're aware of the principles, but that's not where the work is being done. And to claim otherwise, I think, is at least BS.
I have to swallow that for a minute. I think it's a great answer, and I think it's correct. So next 2 minutes is for the originalism nerds out there listening to this. If you're out there, this may get a little abstract, but I want to ask you about this. Uh-oh. So let me tell you my perception on how Randy Barnett evolved on this issue we're talking about. This very issue about interpretation, construction, and where originalism falls in. Because even Randy and Larry would concede most litigated cases can't stop at meaning. You have to go into construction.
That sounds right.
Now, they would concede that. Now, they wouldn't concede how much, but they would concede there's a lot of it. So that's, if I'm mischaracterizing them, I'm sure I'll hear about it, or someone will tell them, and okay. So Randy started off by saying the construction zone. So interpretation simply involves what does the text communicate? And that's going to be underdeterminant in many, many cases, like the one we're talking about. Can Florida regulate Twitter despite the First Amendment on the basis that Twitter is somehow different than other private companies that Florida could not regulate? traditionally under the First Amendment. Okay. So he would say that requires construction. And when he first said that, and for years, he kind of admitted that's not going to be originalist. That construction zone is not going to be originalist. And then, after I pushed back very hard, and other more prominent people pushed back in ways that Randy respects, I don't think he respects my work, but he does respect other people's work, he became convinced, I think, or he changed his mind and said, I was wrong. The construction zone must have originalist content and at least not be inconsistent with originalism. And he had to do that move, I think, because of all the cases you and I both know are underdetermined, and he knows are underdetermined. Here's my question. That move from first, construction is going to be pick a prior, federalism for Randy, deference for Siegel, for pluralistic interpretation for Dorff and Tribe and those folks. Pick one of those in the construction zone, be consistent about it, but it doesn't have to be originalist. And then he moves, no, it has to be steeped in originalism. Is that move BS? I want to take Randy out of it. Somebody who made that move intellectually. Is that BS?
I don't think it necessarily is if one truly believes that the original meaning is so either maybe not determinative, but so helpful
persuasive.
In guiding. Yeah, persuasive, has such an influence in that construction. And earnestly thinks that, I don't think it's necessarily BS. However, I do think that, there is just this awareness of doctrine, other considerations and influences that exist. And I would see the inquiry straying into BS territory in an academic context to say that this is how courts do or should resolve things, and to sort of describing the inquiry in that way and claiming that it's still originalist, even if these other things are happening, they're just guided by originalism. That strikes me as a step perhaps further, getting us more into that shadier, possibly BS territory. So, and I apologize for being so hedgy on some of this, but so much of it does come down, I think, to just the mindset and the level of knowledge that people who are making these claims have, which is why I think that, professors, we run a risk of BS, I think much higher than maybe courts or lawyers, at least on the lower courts, who are just really trying to resolve things, get through the day, figure things out by their schedule, and just working through things the best they can.
Terrific. Great answer, Michael. So you do say in this article that some parts of the originalist enterprise is BS, or and some are not. It's beautifully done. People need to read it. But you also take on the argument that I know Larry, Randy, my friend Mike Ramsey, Michael McConnell, and others would say if they were here, which is you do conclude that originalism is maybe more susceptible of being misused in a BS kind of way than living constitutionalism, pluralistic methods of decision making. You don't take on deference, and I'm kind of on a personal level, I'm kind of curious about that, but I'm not going to ask you about that yet.
I have some thoughts.
Say again?
I have some thoughts on it, though, so
I promise. It's my next question after this line of questions.
All right.
Why is originalism more susceptible to BS than living constitutionalism? To ask this question appropriately, we have to define living constitutionalism. For this purpose, I'm going to define it just as someone who believes that the original meaning of or intent of the Constitution is relevant when knowable, but is only one factor among many, and that the explicit acknowledgement of consequences is legitimate for judges. That's what I'm going to call living constitutionalism. If you agree with that, then tell me, or not add to it or subtract, but then tell me, why is originalism more capable of BS than living constitutionalism?
So I think that's a fair definition of living constitutionalism. The way I do it in the article, which I think maybe makes this particular question clearer to resolve, is to compare it more to kind of a common law constitutionalism approach. You talked about the First Amendment, this idea of we don't really look at the text, but we look at this kind of evolving doctrinal set of rules and interpretations over the decades, over the centuries, and that's what we sort of use to sort of drive the meaning now. And As far as why originalism, I think, is more susceptible to BS compared to a method like that, is the inquiry itself requires a historical investigation that institutionally most actors that are doing originalism aren't prepared to engage in sufficiently. It requires an investigation into history, a rigorous investigation into history, and drawing not only on the law review literature, but the literature of historians, original documents, primary sources. And I think that BS is more likely in a system like that because, number one, you can sort of engage in a selective, misguided use of that history without realizing that what you're doing is necessarily false because you're just not an expert enough to know whether what you're saying is right or wrong. And you can press forward with something that looks great for legal work. And number two, I think originalism lends itself to BS more so because it's harder to check. If you're relying on not cases or analogies or common law style reasoning, but instead on these claims from history, historical evidence, old laws, old regulations, that landscape is harder for other actors in the field to respond to and to call out when false or misguided. We can call out a manipulation of precedent, a missed quote, a false distinguishing instance, because that's what we're trained to do as lawyers. And that's what parties are trained to do. That's what the court and justices are trained to do. But history and engaging in that sort of critical analysis, that institutional training and expertise just isn't there. The rules haven't been created to engage in that. And in that environment, I think we're just a lot more prone to misstatements, failures to check, and as a result, a lack of transparency and candor when it comes to reaching these results through this kind of shadier, less legalistic analysis.
So with due respect to my 123 prior guests or so, all of whom are brilliant, many of whom are Hall of Fame law professors, people like Michael McConnell and Mike Dorff and Reva Siegel and other people like that. That's the best answer I've ever heard on Supreme Minutes in 123 episodes, whatever the episode number is. I think I have nothing to add. I think people should go back and replay what you just said. I think it is. I think you've silenced me, which is the first time that's happened in 123 episodes of Supreme Minutes.
And if there's one thing I can add to that, I explore it, I think, to a degree in the current paper. I have another piece more a little bit farther back called Disingenuous Interpretation. That's where I really dive into that notion and comparing not just originalism and common law, but all sorts of theories kind of along that sort of a metric. So if you want more, that's where you can find it.
So this article is so full and rich of ideas, and I find you to be very full and rich of ideas. There are so many things we can get to, and I want to ask you about, and we have about 10 or 15 minutes left. So I'm going to try to ask two big questions.
Okay.
The first one involves me. The first one is selfish. So in both of my books and in countless essays, op-eds, and law review articles, my view on constitutional law is squarely Alexander Hamilton's view. Not because not because of originalism, but because he was really smart. He was thinking about these things in a veil of ignorance, to use John Rawls' term. Mm-hmm. There was no Supreme Court yet when he wrote his Federalist Number 78. And whatever one thinks of Federalist Number 78 and all of Hamilton's work, it clearly demonstrates that the original idea was very strong deference, that the overturning of laws would be done modestly, with humility, and in Hamilton's words, only when there was an irreconcilable variance between a law and the Constitution, which describes less than 1% of all Supreme Court cases striking down laws. We just don't have irreconcilable variances because we don't pass laws that are irreconcilably. We don't allow 23-year-olds to be president or 5 senators from California and so on.
Well, let's give it a few months and we'll find out.
Fair. That's fair. That's a fair point, Michael. Here's my question. So I've staked my career on that idea, that I think we should have a clear era constitutional test in every case. First Amendment, Fifth Amendment, I don't care. Is that BS?
I don't think so. I agree,
Okay.
and it's entirely because I agree. I am a fan of deference. I'm a fan of humility, which I think is connected to this concern over
Yes.
candor and
Yes.
transparency. The
Yes.
reason why I don't really engage or discuss deference sort of in my theories of interpretation,
I haven't seen it. I haven't seen it in your work. Yeah.
and that's because I see it more as not so much a theory of interpretation, but more as sort of how judges should behave and approach the
That's right.
Constitution.
That's right.
And,
That's
and
right.
my
That's right.
example for that is, I care about what the Constitution says. If I'm pulled over by a police officer, I want to know my rights under the Fourth Amendment, and I want to know how to interpret that constitutional protection. Deference doesn't really have anything to do with me in situations like that. And if we take the judiciary out of it, we want the legislature to make these calls, maybe the executive, someone has to decide. So even if we have a system in which deference is realized, I think that would be an improvement for institutional reasons that I can't get into in detail here, but explore, I think, in the paper. Even then, the Constitution would still need to be interpreted by someone. And that's why I think interpretation is still a deeper question. Deference gets to sort of who does the deciding, but the process of deciding itself, I see as something distinct. Absolutely related, and there's definitely an interplay, but in terms of labeling it as a theory of interpretation, that's sort of where my doubts come in. And then the other sort of minor point or the additional point that I raised, I think Cass Sunstein has written on this as well, talking about how sort of Thayerism or Thayerianism isn't a complete theory, because you have to know when there is a clear mistake, and therefore you need a theory of interpretation to allow that deference to proceed in the first place. I see deference as a consideration that, is absolutely important and something we should strongly consider, but it's alongside, I think, the debates over interpretation rather than as part of that particular discussion.
That is a fascinating answer. So 1A, haven't gotten to question 2 yet. Well, this last round. 1A would be, so I think Sunstein is wrong. And I've always thought this. I think my argument for deference is that it will strongly narrow disagreements between judges and other political actors. My argument for deference, and having to do with institutional concerns, not who can interpret it best. That's not my argument. My argument is these questions are going to be hard and difficult. Who do we want them to decide those questions? And to me, as everyone knows, I think unelected federal judges should do much less than they're actually doing. That itself is valuable to me. Just cutting back on so yes, there'll be fewer cases on the line in a system of strong judicial deference. There will still be questions on the line. I think Reynolds versus Sims is the best example of that. Reynolds versus Sims, one person, one vote, first of all, is obviously good. It's a positive thing. One person, one vote is better than not one person, one vote. But I don't see any legitimate way for judges to get there. But it's so important that there could be some cases like that, but there are very few. But 98% of Supreme Court cases go away if all the judges said, in con law, if judges said, no, we're going to only recognize clear error that we can describe with great clarity. McGinnis says there has to be a duty of clarity. Okay. So I think that objection is not well taken. Just cutting back on controversy, I think, is a positive good. And so I don't know if Cass is right. My question to you is, I don't think you hold yourself out as a leading expert on, the original meaning of Article 3 in the Constitution. But you've certainly done but you have ideas and views on this. Do you think I'm right historically about deference? That was what they thought. That's what they thought. They thought judicial review would be done in the future by judges very aware of their limited role.
I mean, based on my very limited background knowledge, I think there's something to it. I'll confess, though, just as the question is phrased, it's something I haven't really looked into or focused on myself. As far as a good idea, though, and as far as a valuable part of the discussion as circumstances change, I do think it's something we absolutely need to be paying attention to, and I think it's something that I'm paying attention to and continuing to develop my thoughts on, and I am a huge fan of your work pushing that forward and making that point. I think it's immensely valuable. So that's not at all what I want the takeaway to be from my sort of not treating it as a theory of interpretation. It's really an organizational choice, I suppose, rather than a a belief of value.
Thank you. And I appreciate the compliment. All right. You can duck this last question, in which case I'll substitute another question. But I really would love you to answer this question if you feel like you're. So obviously I am not going to ask you any questions about academic originalists and whether you think they engage in BS. I wouldn't put a tenured person in that position, much less non-tenured person. But Justice Thomas, leaving aside, I'm not talking about his obvious, I'm going to say it. This is Eric Siegel's words, not Michael Smith's words. Putting us to the aside Thomas's obvious corruption, his body of work, just his opinions. We don't know anything about him off the page. All we know is his opinions. I have taken the position that publicly, that Justice Thomas take all of his opinions, and what you're going to find in con law that are politically salient, 99.8% of them favor the Republican Party. That's my personal view. I'm asking you about that. Do you think Justice Thomas's opinions in con law, just con law, taken as a whole, amount to BS as you define BS in this article? And if you want to duck that question, just say I don't want to answer it.
Take it as a whole, I'm not sure if I've thought through that question. I do think that some of his opinions do qualify, and I'd be happy to discuss those examples.
Yes. Is Bruin one of those? Is Bruin
yes,
one of
it
those?
is. That was you.
Go ahead.
Took the words right out of my mouth.
Okay. Take this podcast home. Wait. So Justice Jackson called Bruin madness. Just that's madness. I've called it insanity, so I was very pleased when Jackson did that. Take this podcast home with this is Michael Smith, who just wrote an article, Is Originalism BS, telling us why Bruin is BS, and the floor is yours.
I discuss Bruin as an example in the article. This is something I have said and put out there. I think that if you look at Thomas's approach to history, is this the work of someone who is trying to determine historical meaning and truth? I think that is not what is being done there. Although I do think he's so steeped in, his methods, his way of thinking about the Constitution developed over decades, that I don't necessarily think that it's necessarily a lie. Let's be charitable there. But is it BS? I think it is. We're not, and you can look to the treatment of historical evidence, I think, is the biggest key. This sort of breaking down piece by piece of all these laws, all these examples over time, and meticulously distinguishing each one on grounds that are, at best, I think, questionable, and at worst, just sort of what's going on here, and acknowledging that a few work out. The fact that there's sort of this divide and conquer approach to it demonstrates a desire to reach the end, there is no tradition or history. That is the argumentative goal, and the entire inquiry as set forth in the Bruin opinion is crafted around reaching that goal and making it seem obvious to the reader. That structure, to me, is an indicator that is the point of the decision, not some balanced or rigorous historical inquiry. So Bruin, for that reason, is one of the examples that I cite. There's others that are, BS in different ways. Happy to give a couple more if you'd like, but that's my explanation on Bruin in particular.
Would you put Heller in that category?
Heller is, I think, aspects of it are BS. This is sort of the example that I think I hinted at earlier of the sort of crossing the line into BS when you say something's obvious. I think Heller, to the extent that it reckons with historical evidence that can be taken in different ways. You have Justice Stevens in the same opinion, reaching these very distinct conclusions from Justice Scalia. I think to the extent that history is taken in one particular direction, one particular meaning, I think there we are running into BS territory there. It's maybe not because of dishonesty or political preference. It probably plays a role. But again, if we're going to even set that to one side, the court has to reach a decision. This is a situation where there needs to be some outcome. And to the extent that the historical evidence is confused or conflicting or something like that, any approach that reaches a single outcome claiming that this is the historical meaning, I think is very much into BS territory, especially when that meaning is deemed obvious or unquestionable, as I think Scalia sort of asserted multiple times.
That's a great answer. The final bonus question is this. I was so pleased in your article I think you cite me for this. I'm not sure, but I don't care about that. I really, truly don't. I don't. You talk about Justice Roberts in Shelby County, or actually in Northwest Austin, really, but in both cases, where he literally overturned a landmark case and made it say the opposite of what it said by using, on one of the issues, by using ellipses to take out the part that undercuts what he wanted to say. People familiar with Shelby County will get the reference, and people who listen to this podcast will get the reference. He literally said, Katzenbach versus South Carolina said X. It actually said not X. Literally, that's what it is. It said X. It said not X. He said X by using ellipses. My two-part question to end this podcast is, was that BS, or was that quite obviously a case of lying, given that Justice Ginsburg called it out in dissent exactly as I pretty much just described it?
I think we're crossing the line into lying at that point for a few reasons.
Okay.
Number one, call out in the dissent, the problem is right there. Going ahead and doing it anyway when you're on notice of that falsehood, at that point, you know that what you're doing is misrepresenting the source and you proceed with it anyway. That's not just disregard for the truth. That is a knowing falsehood for the purpose of writing this majority opinion and reaching a certain outcome. Number two, and I think you've mentioned this before, Chief Justice Roberts, very smart person, very good lawyer. And
no one doubts that. Nobody doubts that.
And I think to claim that it's, BS or an earnest mistake just simply ignores that fact. It would be sort of, I think, doing a disservice to his intelligence to say that it's anything less. And I think, that is an example, I do think, of though how this is not exclusive to originalism. And I make this point in the article as well.
Right.
Yes, can happen in a lot of places, and I am not at all saying that it's unique to originalism. I do think that originalism lends itself to BS more, but it can absolutely happen in other forums, and I think that is an example that I give of happening in sort of a common law manipulation of precedent, potentially, context.
Michael Smith. The article is Originalism BS, but there's about 40 other articles. You can find them on his webpage. Last week, I had the privilege of having Jake Charles on this podcast for actually the second time for Jake, because guns have been in the news a little bit, and that's his area. But you and Jake are both untenured young law professors who are doing unbelievably amazing work, and you're not at Harvard and you haven't been there for 20 years, and so you don't get the publicity that you should. But I want everybody to read your work. It is really thoughtful. That's obvious from talking to you, if people reading your stuff. And I am really looking forward to following your career, because I think there are some sensational things in store for you. Thank you for being on this podcast.
Thank you so much. I appreciate it again, and it's been a blast.
Thanks, Michael.